Hey brothers and sisters, this is Bartok888 and Kristen speaking, and this is a really important video actually. This is for my friend Matthias, who suspects that it may be a conspiracy theory to post a bond for your court case. I want to let him know that it's not a conspiracy theory at all. In fact, people post bonds every day, especially in a court case. As well you should. In every court case, always put in a bond. Now, it's important to understand that every legal matter is commercial, okay? By the way, this is not legal advice. I do not offer legal advice. This video is for educational purposes only. If you have a lawyer, you should instruct them to post a bond for you before the court date for entertainment and educational purposes only. If you do seek counsel, brothers and sisters, as well you should find a competent counsel. If you especially have harmed someone, this video is not for you. This is not in regards to a case where there's an injured party or someone's been harmed, okay? This is for court cases where there is no injured party. But just be aware that when you do have a lawyer represent you, you are a ward of the court. You cannot speak, you cannot talk. You are a ward of the court means you are not capable of handling your own affairs. So make sure that that's what you want to do. Many people are just representing themselves just fine. Now, as far as posting a bond goes, it's not an argument, it's not a plea, it's just a bond. Who can object? The court bond is a special bond as described in Rule E of the Supplemental Admiralty Rules in the Federal Rules of Civil Procedure in 28 United States Code. For example, bail bonds, general bonds, specialty bonds. You'll see gold fringe on the flag, brothers and sisters. I'm sure of it. And that lets you know it is Admiralty and Maritime jurisdiction. Now, once you post a bond, now no controversy exists. You cannot be required to pay any claims for any losses or costs because you have covered any and all of them by providing a bond for settlement. A court exists to solve disputes. Now there isn't one. Your obligations are discharged via the bond. No plea is required, whether there is an assessment or not. Now please understand that the judge is the trustee. Instruct him to settle the matter via the bond. A good plan is to file it at the last minute, notarized, just before going to court. Do not go in there unless you've done this. Send a copy to the court administrator. Now, alert. The prosecuting attorney will be mad. He's going to be hot. He's on the hook. So be on the alert. Be ready for that. Now that you've posted the bond, super important. Now there's a separation between you and your name in all caps. They cannot take half a body to jail, but only the all caps can go to jail. Brothers and sisters, I hope you realize that you are not your name in all capital letters, which represents something that is dead, something that is a fiction. Okay? Now, the beauty of posting a bond, a court bond, is that within 72 hours, they must dismiss or pay out of pocket themselves, the prosecuting attorney. That's why he's going to be hot. Important, you will also need to file it soon, the UCC1 financing statement. With a financing statement which includes clarity that the natural man and real being is the living principle who autographs instruments and operates in the capacity of being the authorized representative, attorney in fact, and secured party for the all caps. Otherwise, they own the all caps and they can do whatever they want with it. I recommend that you watch the Deprogrammed Enlightener on YouTube for legal matters. and educational in regards to becoming secured party creditor. Also watch Tex Mason, USFL, a Texas Cash 3502, and go to understandcontractlawandyouvin.com. Remember to let the judge know that you are here in regards to that matter. Do not jump up when they say your name, because when you agree that that's you just agreed to be the all caps, and you're done. So you always respond, I am here in regards to that matter. Practice one time for yourselves, brothers and sisters. Say it out loud. I am here in regards to that matter, as the authorized representative by special appearance to settle the matter. Judge, Your Honor, since you are acting as trustee, what more information do you need from me to settle this matter? Can you see that I have posted a bond for discharge? Creditors ask questions to figure out how to solve a matter. Don't make statements. Ask questions. Every crime has a penal sum attached. They are collecting a debt, brothers and sisters. You will go into default judgment because you don't know about it. Is there an injured party? No. Then see ya. Let them know you're doing a letter of rogatory. You want an accounting of the total amount of the bill for settlement and closure of the account. The courts are never wrong. Don't argue. If you argue at all, they automatically assume you are the debtor, and the debtor always loses. So you learn how to conditionally accept or accept everything for value and stay in honor at all costs. He who goes into dishonor first loses. You have to accept for value the case to bring it into the private side. I accept the case for value and return it for value. Now you have removed yourself from the status of chattel, which is a 14th Amendment U.S. citizen, no rights. You want to be a national citizen of the United States of America, not the United States. The United States is a corporation, brothers and sisters. Now you are acting as secured party creditor. Now you have rebutted the presumption of debtor, voluntary slave. Now your status is secured party creditor. Creditors always win. Debtors always lose. Always. Now, a little further explanation here. Basically, there are surety bond companies out there who will take care of posting the bond for you. You can see many reputable surety bond companies online. Creditors, CEOs, and players know about court bonds, which are used every day, hundreds of times a day in court. There are many types of court bonds: plaintiff bonds, defendant bonds, criminal, civil, traffic, DUI. All are surety bonds. It is similar to a bail bond, but different. The surety bond company is an insurance agent. Every crime, every charge against you, civil or criminal, has a penal sum attached to it. You need to find out how much it is. Unlawful detainer. The Superior Court is limited jurisdiction in that matter for $25,000 or less. So, you will pay 1 to 3% of whatever the amount is that the court requires to the surety company. They will go ahead and post a bond to the court for the whole amount, whatever it is, so that if you lose, the opposing party will get paid via the bond, instead of you going to jail or getting a guilty charge on your record, for any and all charges that may incur for that court case. If you win, the surety company keeps the fee. If you lose, you will work out a payment arrangement with the surety company, like a loan, and it will be between you and the surety company. The court is dealt with and paid. The case is resolved. You stayed in honor. You did not go into dishonor. See, the plaintiff's attorney was supposed to have posted a bond himself when he filed the case. He and the court clerk are betting that you will default. You need to know if the opposing party has posted a bond or not, so ask the judge. Either way, once you post your bond, they have 72 hours to dismiss it or pay out of their pocket since you didn't default. Brothers and sisters, never go to court without posting a bond. Never agree to be the all caps. And stay out of jail. I love you a lot. Thanks for listening.